For those who, can you guys hear me? This won't work. Hello? Oh, for those of you who want to sign up for a bell, we're actually getting the sign up sheet real quick. So it'll be in the back in just a minute. And once everybody does, we'll go ahead and get started. Where is it?
It's right there behind that door. I can bring it for you.
Yeah, that'd be great. I feel so. Okay, never mind. Okay. Everybody sign up that wants to speak to a bill. Okay. We are going to go ahead and get started. Welcome to Judiciary Non-Civil Subcommittee. We're going to go ahead and have Representative Mathis come up for House Bill 932. Good afternoon.
Thank you, Chair Lady. I appreciate it very much, members of the committee. Today I bring before you House Bill 932, LC 480977. Is that the same thing we got? Okay.
That's correct.
This has to deal with fentanyl. I don't think I need to indulge in how serious a issue this is. That we've been talking about it for years. We've tried to get some legislation passed to directly approach this in a way that we can deter folks from using this lethal drug in other drugs and other ways that are detrimental and causing death to citizens all over the country, all over the state, even in the small town that I live in, with 12, 14, 15,000 people. We've had several cases already, fentanyl death. So if you'll look at the bill, if you have any questions, I will go over a couple of things. I do want to say that I have Mr. Robert Smith with me with the General Counsel with the Prosecuting Attorney's Office. He has extensively helped me along with Pete Scandalakis on this, the Executive Director of the PAC, and I appreciate it so much. I have a personal interest in this too. I've had a very, very good friend of mine lost his daughter in her 20s to a case like that, and then with less than a year had a friend of mine's son die down in Statesboro right after he graduated with a biology degree, celebrating somehow got a hold to some drugs that had been laced with fentanyl. We deal with it on a regular basis. But what we're doing here with this bill, HB 932 creates an exemption to the court-created elements for deaths that arise when a defendant manufactures or distributes to another person fentanyl or another controlled substance that contains fentanyl. This change would also apply to the derivatives of fentanyl as well. It says nothing else changes. The procedures or punishments surrounding murder are the same. And the bill does not apply to all drugs, only fentanyl. Marijuana, cocaine, methamphetamine, and heroin will not be included unless the drug dealer is mixing those drugs in fentanyl. And we have current law, and then we have the Supreme Court had added some additional requirements. And if you would like for me to state that, I'd be glad to, but if I think we probably know and we can look at it, I'll get you a copy of that. But I did want to make one little visual that was given to me. If you take this penny and you go over the date and you put one speck, about 2 milligrams of fentanyl is lethal. If you take the carfentanil, which is used to tranquilize elephants or rhinoceroses or things of that nature, it takes 0.2 milligrams of that. I'm talking about just a dot on a penny. And that's what we're dealing with. And that's why we need to try to do something to deter these folks from even attempting to put it in other drugs. So, Ms. Chairlady, that's what I have to offer. If there's any questions, I would like to turn any questions over to Mr. Smith. He's a professional on this, and I'll be glad to try to help any way I can. But that's what the bill does.
Thank you. Robert, do you want to say something or just here to answer questions?
Thank you, Chairwoman. I'm here to answer questions. I just would point out that this is a serious issue that is being addressed. This is one of 5 bills that is aimed at this specific topic. Each one does something a little bit different. I can tell you that the DA's Association is looking at all 5 bills and have not given a support of this is the preferred bill of the 5. But each one of the 5 does something that is aimed at the policy that Representative asked me to look at and provide him and assist him with. So I'm here to answer any questions anybody might have about what this bill does or doesn't do.
Okay, great. Thank you. We have a few questions. Is that Representative Byrd? Okay.
Thank you, Madam Chair. Thank you, Representative, for presenting this bill. If I remember correctly, we had quite a discussion last year about this bill, and there was concern, and I believe I also asked the question, so if you're at a very large party, and someone starts handing out fentanyl, who is going to be charged, and how do you know exactly which person has given it out? Thank you.
Thank the representative for the question, and that's a proof problem. That is currently right now the way our law reads is that if you distribute, basically the distribution of a deadly drug or distribution of a dangerous drug, controlled substance, is punishable. So if you're at a function and someone is intentionally or knowingly passing out fentanyl, and that's what you start looking at the different statutes and what each one of these bills does. All this bill does is it goes in and says we have our malice murder in the murder statute. We have malice murder, we have felony murder, and then this would be a third way of committing murder, and that's when during the commission, like when you're possessing with the intent to distribute or you're distributing fentanyl, you cause the death of another person.
Do you have another question?
Just kind of more clarification. Sure. So it still really doesn't answer the question, because if I'm at some very large event, we really don't know who has given out that fentanyl. So, but thank you very much.
All right, I have another question. Representative Miller.
Thank you, Mr. Chairman, and thank you for your bill. Thank you, Madam Chair. Just a clarification question, and maybe Robert can answer this. Is a prosecutor able to prosecute a fentanyl-related death under our current felony murder statute?
Yes, ma'am.
Okay.
And they have successfully.
Okay. So would this be just a clarification of what is already existing, or how, because when I say irrespective of malice, when I see irrespective of malice, I'm assuming this is sort of felony murder.
It is.
Okay. So are we just clarifying and putting people on notice, really clear notice, that fentanyl distribution or manufacture, whatever, can result in a felony murder conviction?
It could be interpreted that way. What's happened is that right now, the law that was created says that if someone dies in the course of a felony, and I'm kind of paraphrasing, I'm not using exact words, but if somebody dies in the course of a felony, it's considered felony murder. Our courts have read that and said, well, what the legislature meant to say is that it has to be a dangerous felony, and the act has to be proximate, the proximate cause of the death. There have been additional elements added to felony murder. So this statute could be interpreted one of two ways. It could be either interpreted as to, well, when it comes to fentanyl distribution, you don't have to show those two elements and other elements, or it could be just a clarification as to make sure everyone understands that the legislature really means that fentanyl and fentanyl distribution should be treated this way.
Okay.
And I'm not advocating one way or the other way, but those are two possible interpretations of it.
Okay, I think I understand. And then secondly, if I may, Madam Chair, the individual who is selling the fentanyl would have to know that they're distributing fentanyl. In other words, I'm thinking of a person who perhaps purchases a fentanyl-laced marijuana cigarette, and then they sell that to someone else, not knowing that fentanyl has been laced in there. Can you talk me through how that would play out in terms of how a prosecutor would view that case?
I'm trying to find the statute to be able to, the case to be able to give it to you, but my understanding is that there is a knowledge element that you have to know that you're selling something. And the question, then it's up to us to prove what the substance was that was being sold.
Okay. So then a person in that situation, in my scenario, if they would have the ability to defend by saying, I was only selling marijuana, I was not selling fentanyl, thus this subsection would not apply, although another one might.
And I'm going to apologize to the representative because I know that I should know the answer to that question, and that's why I'm frantically looking through the cases, because I don't know the answer at this exact moment. My brain is not working.
Okay.
So I don't know the answer
That's
to that.
okay.
Can I just add one thing?
Sure.
When we tried to do this bill earlier, we were trying to make changes to statutes that were already in place. And we felt like that was not what you need to do. We already had them in place. Why change something when you got it? We're just trying to add the speculation that if you knowingly are dealing with fentanyl and it's put in any other drug, you are going to be held by the statutes that's already on the books. That's what we were trying to. There was no need to try to draw up a whole new set of laws for a certain thing. It was just adding that one element to it. And I agree. It comes down to anything, you being a prosecutor. It's tough proving some of these things. Representative Byrd, I understand that. But we have to do something to try to, for a better word, if you put teeth in it, to try to deter them to be a little more particular. Now, whether that's going to work or not, I don't know. We've tried, but we got to try. Okay.
For possession, you have to intend to possess something. You have to exert the control over it. So that's one of the things we've always, and I remember charging, that you have to actually intend to possess the controlled substance. So I would believe that if we're charging someone with possession with intent, there has to be a knowledge element that they knowingly possessed or they knowingly intended to possess the object. And I'm sorry, I apologize. I'm not prepared to answer that question.
And I believe I had the same question last session. I remember,
It's okay.
and I'm trying to think. We may have had that kind of language, and it ended up being more confusing. So, but we're going to look into that. But thank you. I think that's all the questions. We do have several people signed up to speak, so I'll go ahead and start calling them up. The first one is
Thank you. I'm sorry.
Jeff Breedlove.
Breedlove, here for the Georgia Council for Recovery and a person in long-term recovery. Want to begin by thanking the author of the bill for his compassion and what I know is sincere desire to protect people and save lives. But with respect, I think this bill is just not quite ready for prime time. I think it is kind of like taking the ultimate nuclear weapon to this, and we're going to have some unintended consequences. I would suggest to you that line 12, the phrase irrespective of malice, gets to the point where maybe it is to that scenario, a person at an event that has the marijuana-laced fentanyl. Irrespective of malice, it had fentanyl in it, so we're going to send you away for the rest of your life. I would also suggest that on line 18, what really scares me to death is the phrase, a person. I would suggest to you that there's a lot of people involved in this process. And let me be clear. Somebody's got to go to jail. Don't misunderstand me. There are people spreading poison to my brother and sisters. I may have been to more funerals in this room than anybody else. I want to see the right people go to jail for the right reasons. But I do not want to see a person with a recognized medical issue, recognized by the federal government and this state government, who's in active addiction, who passes a consumable, not a distribution amount, but an amount that they're using, consumption amount, to their friend, or maybe even a stranger at a party, but says, hey, I need $10 for that. Hey, guess what? You just sold drugs. And now we're going to say the answer to that is to put that person in jail for the rest of their life? That person needs medical help. They're not the bad guy. They're the person that needs help. So I think it's too broad of a brush. I'd like to just say also language like, which I think ironically is in another piece of legislation that's going to be heard before this committee. There's language that could be used like, in the court's discretion, the judge may depart from what is in essence a mandatory minimum sentence, specified, and allow prosecuting attorneys and the defendant to agree on a sentence that is below a mandatory minimum. There is language that your legislative council has come up with that provides the third branch of government, the judicial branch of government, to use its discretion, its discernment, and I might add, at the local level, where folk know each other, and say, Breedlove is a drug dealer. We want to send him away for the rest of his life. But Sally over here, she was a person in active addiction. She's not the person we want to go. So let me just say this. There's some 900,000 people in recovery. There's a greater number of that, of families that have lost a loved one to the disease in this state. Let's get the right answer, but a broad brush will have unintended consequences. Thank you for your time. And I'm happy to answer any questions, Madam Chairman.
I don't see any questions. Thank you.
Thank you, ma'am.
John Langstrom?
Oh, ma'am, you
Sure.
had to leave, sorry.
Who did? John?
Yes, ma'am.
Okay. Okay, that is all. And Representative Mathis, do you want to have any additional comment?
Not really, but just to say thank you for listening. I think we need to address this. I'm definitely open to make sure we get it right. I do not want to do anything that would harm somebody that may not have committed this, but on the other hand, there are people out there that may not know that the fentanyl is there, but they are dealing with dangerous things, and there's their potential. And somehow you have to put a stop to that. And I think that's what we need to do. I'll contend that. I want to help folks, but we have to stop what's going on. Thank you.
Thank you. Okay, we're going to move on to our next bill.
Thank you.
Thank you. And I'm just trying to scan the room for any representatives that are here. I know Representative Reeves, I know you're here. I'm going to wait on your bill for a minute. Oh, Oh, okay. Representative Vance, I know you've waited a while in a few of my other subcommittees, so.
Thank you, Madam Chairman. I'm working off of LC 48119-7S. Is that the one you have?
48, yes, it is.
All right.
It's LC 481185S.
97S.
Oh, okay.
It was given, I know it was finished around noon today. And Mr. Hines said he handed it on the right
I'm
places.
sorry, say the number again?
All right. LC 481197S.
Okay, we do not have that copy. Can you check on that? Do you have a copy for us? And we can go ahead and make copies.
Then why don't I wait and you go to someone else? I don't know.
Okay, we'll take on
That's fine.
one more bill before
That's fine.
yours.
Thank you.
Thank you. Representative New. House Bill 1056.
Thank you, Chairman and members. I appreciate the opportunity to speak to you today about House Bill 1056. We're working with LC 570050. Currently in Georgia, there's a lack of substantial penalties for selling drugs to individuals of any age. While the maximum sentence is 5 years in prison, it's often probated, resulting in no real consequences. This bill enhances penalties for adults defined as 21 years old and older, selling drugs to minors, which is defined as 14 years old and younger. Offenders would face a mandatory minimum sentence of 5 years in prison without the possibility of probation, deferral, suspension, or stay. The court does retain the discretion to deviate from the specified mandatory minimum sentence if all parties involved agree, which includes the judge, the defendant, and the prosecuting attorney. An average of 22 U.S. teens age 14 to 18 die each week. That's a classroom full of kids each week because we weren't tough enough on those individuals who were trying to harm them. The current state of the drug crisis, with fentanyl claiming the lives of our kids, highlights the urgency of taking action. We have to do something bold. We've got to save them. By safeguarding our kids from drug use and ensuring they do not stay down this destructive path at a young age, will foster a healthier future generation. This bill serves to send a clear message to adults targeting our kids. Selling drugs to minors will result in significant prison time. By implementing this enhancement, we hope to deter individuals from endangering the well-being of our minors. And this is what this bill does. I'll take any questions at this time.
Thank you, Representative New. Just to confirm, we're working off of LC 570050.
Correct.
Okay. Any questions from members? I'm sorry. We'll get it. Representative Miller.
Thank you. Thank you, Representative, for your bill. I just had a couple questions for you. So is it any drug, or, so for instance, in my mind automatically differentiates marijuana from, say, fentanyl, right? So I'm just trying to understand if there's any limit to what kind of our drug code is massive.
Yeah.
Or is it any drug, or is there a class of drugs that you're trying to get at?
I believe with the first, I had put in there different codes, but this one is any drugs, because you're looking at 21 and 14. Anyone older than 21 and older, 14 and younger, regardless, they don't need to be selling drugs to those people.
Body ever.
Agreed. Agreed.
You know, illicit drugs to anybody ever. But I think some of the concern, which I think is a valid concern, is, you know, I'm assuming that the person would not have to know the age of the person they're selling to. It's just as a matter of fact if they sell. So if a 21-year-old sells to a 14-year-old who he or she did not know was 14-year-old and sold them some quantity of marijuana, your intent would be to have that person either receive nothing less than 5 years incarcerated, unless there's some move to depart by the judge, the prosecutor, and the
Correct.
and the
There
defense
is-
attorney.
Yes, that is correct. And this is, right now it is 5 years for anybody selling drugs to any age, but it's usually probated. So we've got to be tougher. This is not working. We are losing the battle, and we're losing our kids. So we've got to do something. And so this is what I think is good. At least it's a start in the right direction. If we can get them at 14 and younger going down the right path and deterring these people from targeting them, then maybe we can save them from a future of abuse, substance abuse, and possibly death. So,
Okay. One more follow-up, Madam Chair. Thank you. Well, actually, two parts. One, have the prosecutors weighed in on this bill to say whether they need it or support it, or just any opinion one way or another?
so my local prosecuting attorney helped me with the wording, and that's where when it came time to define what the ages were for adult and minor, that's where that came from, as well as the court retaining discretion to deviate. That gave them the chance, because they do know them. These are local people, and they can say, you know, we know you, we're going to help you with the issue. So this does still give them, a deviation to work with. And it has not been approved yet by PAC, but I'm still working with him.
Okay.
So,
Okay. I guess I'll.
yes. Thank you for the question.
Representative New, I have a question.
Yes.
Is there a particular reason you chose 14 years of age or younger?
This was because, speaking with my prosecuting attorney, so that if teenagers were at a party and someone gave someone or sold someone at this party marijuana, then that would take that out of the picture, because we don't want to go there. We want to make sure that we're getting the kids before they have a problem, and so that's why we want to make sure that I don't want the kids that are selling drugs to kids. I want the person that sold the drug to the kid. I want the adult to pay. I want the one that knew that he was targeting our kids, because he knew that's going to be his potential buyer in the future, and he doesn't care what happens to them. He wants them to be addicted so that he can keep them in his stream of cash flow for the rest of their lives and their friends. So that's why it was that way. I want to catch it early so that we can stop it and prevent it.
Okay, thank you. We have a few people signed up to speak, so I'm going to start calling on them. Thank you, Representative. Maisie Lynn?
Madam Chair, she had to run to Senate Judy. She'll be back.
Okay. Jeff Breedlove?
Thank you, Madam Chair. Jeff Breedlove, Georgia Council for Recovery, Person in Long-Term Recovery. This is a bill that we kind of go somewhere between support and oppose. This is a bill worthy of debate and discussion. It's a bill moving in the right direction. Who wants to stand up here and say we don't want to protect children from, not me. I do appreciate and am very thankful for the language in line 27 that goes through line 30. I think that language is what gives this bill hope. Because again, we want people to go to jail that are targeting children for absolutely sure. But we also want there to be discretion in case it falls in the scenario you said. Well, what if it was the person to person, not the real bad guy? So, right, exactly. And look, we have no comment on the age, 14, 12, 13. That could be debated for a million years. But I respect the author's intent, and we would, I believe our organization and our community would love to see this bill move forward so that we could see debate and perfection on the bill as opposed to the process not move forward. We've got to do something about this, and maybe this is a vehicle that we could have a discussion appropriately and publicly about. Any yield for any questions, ma'am?
No questions, thank you.
Thank you, ma'am.
Maisie Lynn, saw you coming in.
Thank you.
We're on 1056, House
Maisie
Bill.
Lynn Gerton, the Executive Director of the Georgia Association of Criminal Defense Lawyers, and I only caught the tail end of the last speaker, but our concern is simply the mandatory minimum nature of the sentencing scheme in this bill, and just always come to remind you all that the judges will certainly sentence up to the maximum in those scenarios where it's necessary, and would respectfully request that you allow them that discretion rather than making it a mandatory minimum sentence.
Thank you. No questions.
Thank you.
Do you have a question? Just comment underneath. Okay, I think that's everybody. And I think we can certainly agree on this bill and the previous bill. We need to do something. I think there's more conversations that we can have, and to try to, like I said, and like many have said, that we can get to a point where we can have a good bill. So thank you for coming today. All right, Representative Vance, I believe that we have your copy, the latest copy. So that is House Bill 922. And that is LC 481197S. Is that correct?
That's correct.
Okay. You may proceed whenever you're ready.
Thank you, Madam Chairman, committee members. This is a bill that was heard possibly 3 weeks ago in a hearing. There's been numerous revisions since. I think some of the language that were in some of those revisions will appear in an upcoming bill from another representative. But here's what I have today that's really germane to what I was trying to accomplish initially. The only change is, if you'll look on line 35 through 39 and capitalizing one word in 29. Notice to the part of that entry, criminal trespass is what we're talking about here. And this would give, per prosecuting attorney's counsel people, this would give a peace officer at the request of the owner and rightful occupant or authorized representative of the owner to remove that occupant or that person that's there without being invited, and make the criminal charge if necessary. If the officer in his or her discretion decides, they could make that arrest for criminal trespass. Currently, we don't have that opportunity. I say we, law enforcement does not have that authority under law. This just gives them that under this this narrow circumstance under the law. But these kinds of things happen more where someone just wanders onto your property, decides to sit there. The owner is alarmed, calls 911, does not say anything to the person who's wandered onto the property with the expectation that law enforcement will handle it. Well, they will, but under current law, they cannot make a charge. They cannot make a charge because this language that we have in this bill is not in current law. So that's all this does or attempts to do, and I'll be glad to answer any questions.
Okay, Representative, thank you for working on this. I know we had a good conversation last time, and I believe we have one question. Representative Byrd?
Thank you, Madam Chair. Representative, so I'm trying to understand this. So if I go on someone's property and I have trespassed, I have not been invited there, you call 911, the police come, and I can be arrested for just being on your property. Is that correct?
Yes, if I did not give you consent, and some people, if they have a sign that says no trespassing, and I come on there, well, they've been warned already. But if in front of your house you don't have a no trespassing sign, I wander onto your property and sit down on the front porch, as happens. It happens a lot, particularly in rural Georgia. And I'm not an Atlanta or a metro Atlanta person, but people just wander on the property and sit down. Yes, they could be charged under this bill. Under the current bill, no, they could not. Under the current law, they could not.
Thank you. One further question. So I need to have a sign in my front yard that says no sitting on my front porch or no squatting, or otherwise you would call the police on me? Is that correct?
That's possible, though, and I'm not saying it's right or wrong, Representative Byrd. I'm not saying it just is.
I'm just asking.
You're good to go.
Thank you.
And can you, Representative, I think you gave this example last time of what brought this bill up. What were some concerns that you were hearing?
What I was hearing from law enforcement, particularly in Central and South Georgia, was that these kinds of things were occurring. But under the law as it stands today, if I came onto your property without your knowledge, and you discovered that I was there, and you called 911 without ever approaching me. You didn't holler out the door. You didn't shout out the window. You called 911 immediately. The officer came per your 911 call. Under current law, all that officer could do was ask that person to leave. That's all they could do. This will, if the person acts out, then they can per, and I want them arrested. Well, that officer could do that, but not the way current law is situated. And one of the sheriffs is a lawyer, and he said he just can't do that.
Okay, Representative Miller?
Thank you, Representative Vance, for working on your bill. I just want to make sure that it's effectuating what I hear you saying you want it to effectuate. Right now, if a person walks onto another person's property, not for an unlawful purpose, they just wander on there. Typically, they would have to be given a notice by the owner that they cannot be there. And then they'd have to come back again, and then they could be arrested because they have been noticed that they are not allowed to be on the property. Is that your understanding?
Yes, ma'am.
Okay. Your bill is allowing a police officer to give that notice instead of the property owner.
That's correct.
To the person that says, hey, you do not have permission to be here. As I read this, because I'm missing something, the officer would still have to go through that process of giving the person notice, then the person coming back for that person to be arrested? Or is your intent to make it so that the officer could arrest the person without any notice if they find them on someone's property without permission.
This gives that officer that discretion, if you will, to make that charge upon the first time without giving a warning, and say, "Here, ma'am, I've been a lawman 51 years. I've had a bunch of these in my life." You go up there, you go up there and you say, "Look, sir or ma'am, you don't have any right to be here. You must go." That's all I could do at that time. This way, I could go up there, and this may not be the first time that's happened. This may be the second, but the officer has the discretion that when he says, "You're not supposed to be here, I'm arresting you for criminal trespass," which is a misdemeanor, and go forward. I know we like to build laws on the running chance. I got it. Give people opportunity to do right, and I think using officer discretion in this situation is the absolute right thing to do. And generally, that's what's going to happen. You're going to say, "Sir or ma'am, you can't be here. You must go." They leave. There you go.
I understand that, and I'm not saying I disagree with it. I'm not 100% sure that as this is drafted, and I mean, my colleagues are smarter than me, I'm sure they'll chime in, that the officer can do anything other than give the notice. I'm not sure that we have.
Under current law, the officer can't give the notice.
Correct.
This would give the officer the ability to give the notice.
Correct.
And I'm gonna say 99 times out of 100, they're gonna give that notice. That's gonna solve that situation, and you move on.
Okay.
I'm just.
No,
I
I'm not
feel like
disagreeing
the
with you.
messenger here. You know, I'm just the messenger. But this thing has gone through about 9 iterations since we had the last hearing, and we've really come back around to pretty close to what we started with.
Representative Vance, I'm sorry. Are you talking about this one?
Yes.
Okay. Are you sure this is the right version? Is that what we're talking about?
It's the version that we finished today around lunchtime
Okay.
with Legislative Council.
I think Representative Reeves.
He's got another,
Oh, I see.
he's got another
okay.
another thing.
I see, I
okay?
see, I see.
And
Okay,
it
no,
was an
you're,
earlier iteration of this one, but his bill actually goes much farther than mine.
okay.
So.
And that's your bill, so we're gonna
might
hear that
solve-
later.
That might solve y'all's problem.
It's an amendment to 922. I'd be glad to address it. It's in your folder. It's
It was,
481197.
Well, Representative Reeves, you're not in this committee, so you can't have an amendment to a bill that is in this committee.
It was my understanding the author had given it to the committee. It's 481185.
Again, I don't
I can
think,
explain to you how it occurred
well,
later.
okay, so we're not at the point where we're doing amendments. There hasn't been anybody that has offered an amendment. And certainly we can get to that point if we need to, if we move forward with a motion to move on this. But currently, what you have presented to us is this version.
Correct.
And that is what we're considering.
Correct.
And again, if there is an amendment later, we can discuss that as well.
Correct.
All right. And so, going back, I think Representative Miller, what you were saying, I'm going to kind of piggyback on that and clarify. As I read what this does is essentially you are allowing that notice to be given, and it may be given by law enforcement.
Correct.
Correct?
That's
And that is essentially the only thing that you are
That's
changing
correct.
at this point.
That's correct.
Okay. Whereas before this change, it would have had to come from the owner of the
Correct.
property.
Correct.
Okay. All right. Any other questions from committee? All right. I believe we have one person signed up to speak on this, and that is Thomas Weaver.
Thank you, Madam Chair, for recognizing me to speak. Members of the Hong House Judiciary Non-Civil Committee, I rise today in respectful opposition to the legislative proposal that's being advanced by your colleague, Representative Vance. Unfortunately, I did not have an opportunity to review the substitute version of the bill, but based on what I was able to glean from the author's comments to the committee, I can kind of launch from there and kind of make an argument. First, I want to kind of lay a little foundation here. If the House should recall, earlier this month, House and Senate conferees agreed to Senate Bill 63 that was proposed and is now heading to Governor Kemp. House Bill 63 includes a modified provision under Georgia Code Section 17-6-12, subsection A, paragraph 1, and creates a new subparagraph, double capital H, which provides that upon a second arrest for criminal trespass, that defendant is to be held without the possibility of bail. It's an automatic no bail, no judicial discretion. So if a criminal defendant or if an alleged criminal defendant under this measure, should it become law post July 1, if that's the way that the measure is worded, should have the unfortunate misgivings of having a prior criminal trespassing in their GCIC history. If they're apprehended for a new criminal trespassing offense, should SB 63 become law, that criminal defendant is automatically no bail on the spot. And it bothers me because the way that the representative presented the bill, even though, again, I don't have the privilege of having the actual material in front of me, it would apply to broad land. It wouldn't just apply to actually inside a dwelling or inside a vehicle, although those prospects are certainly possible, the way that the measure could be worded if I had it in front of me and the way that current law exists under 16.721. But it would apply to broad land. So imagine if you had an acre and someone came upon it without your permission, that individual would be a criminal trespasser by default. So I would ask this committee to consider two prospects, please, if it should be the will of the committee and if the chair should choose to allow it. Madam Chair, members of the committee, I would submit to you first to take into consideration the bail restricted offenses measure that's going to be presented to the governor shortly. And I would ask that if that should weigh into the committee's consideration of the bill, to consider two slight, small modifications to the bill that might add value to the measure that Representative Vance, your colleague, is trying to advance, especially for concerns out of South Georgia, but to do so in a way that might moderate or provide an even hand at the table for this measure. The two things that I would ask the committee to consider are, number one, whether or not there should be an adjective modifier or moniker incorporated in the statute to provide that it has to be private property and not just any property, such that public property would be excluded from this. It wouldn't be fair for a person to be able to be criminally trespassed from property that they jointly own through taxation to the same extent as a private land. So if the representative sentiments are to go after someone who enters onto a fenced a yard or a porch, I would ask that the committee consider if it should be the appropriate posture of the committee, if any amendments should come forward through for deliberation for the addition of the word private. That way it would provide a prosecutorial element of proof that there has to be a private property consideration. And then the second thing that I would ask, and looking at other earlier renditions to the bill that I believe Representative Reeves spoke to the committee, although the chair shared that those were not appropriate at this time. I believe that there were other versions of the bill in previous renditions under previous LC numbers that had different elemental requirements, like an elemental train, such as with the intent to threaten or the intent to harass. There were different versions of this that's been floated around. I would ask if the committee would consider putting some of that language in there too, such that an alleged criminal defendant could not be held just for want of mere presence, but that it would have to be on private, and there would have to be some type of threatening or violent component above and beyond a mere presence. But those are my only two thoughts in addition to the bail consideration, Madam Chair, and thank you for recognizing me to speak.
Thank you. And I'll just kind of clarify where the current law is of criminal trespass does include knowingly and without authority. It does speak of entering upon property of another person. So I think we're not changing that part. I think that it's already law that it is, you have to knowingly and without authority be entering into somebody else's property. The only thing I believe that Representative Vance's bill is doing is essentially not having the owner of the property give notice, or they can have law enforcement come and give that notice of that criminal trespass.
Thank you, Madam Chair, for
Thank you.
sharing that. I didn't have the substitute in front of me. I will share just one last thought if the chair will choose to allow
Sure.
it. Under Georgia Code Section 16-1-3, providing for definitions for the entire title of Title 16 of the Official Code of Georgia annotated, which is applicable from the first to the last section of the entire title, which spans 3 volumes. Person is defined to include government. So I would ask the private consideration.
Thank you. All right. Do you have any type of response before I take up any motions? Representative Vance? Sure.
This bill is really adding to a long-standing thing of officer discretion. Officer discretion. You give them the ability to do something, to give that notice, but you also give them the discretion of whether to take action in a criminal case or not. Currently, they have no discretion because they have no power. This would add to that responsibility of the officer to be judicious, to in some cases be humane, and do the right and appropriate thing given the circumstances. So I'm trying to add to the officer's ability to enforce a law that currently that officer cannot enforce in this particular instance, and give that officer the discretion of whether or not to do so after notice has been given. And that's all I would comment. Thank you for allowing me.
Good. Thank you so much. And we'll keep it a hearing only today. Thank you, Representative. I should have made this announcement in the beginning. I apologize. It slipped my mind. But House Bill 1014 is on the calendar. We have actually taken that bill off of the calendar for today at the request of the sponsor. All right. Representative Gaines, House Bill 1201.
Thank you, Madam Chair. I really appreciate it. And joined by Jay Neal, who's the Director of the Criminal Justice Coordinating Council, if that's acceptable. And I'll be extremely brief. I believe this is a common sense measure that is really just trying to address a loophole in the Survivors First Act that this body passed, I believe, unanimously previously to help survivors of human trafficking that do end up with a criminal record as a result of the experiences they've gone through. And what we're trying to clear up is it would apply to survivors who are sentenced under Georgia's First Offender Act or conditional discharge. Those were left out of the bill, and so this is just cleanup to try to address that. There actually is at least one and probably more ongoing cases. There's a lawyer here, Brian Atkinson, who could speak to that if necessary. But I believe this should be hopefully something we can all agree on to continue to help survivors of human trafficking. Georgia's just done tremendous work, especially under the leadership of First Lady Marty Kemp, to try to make this issue a priority and try to help survivors of human trafficking, and also go after those the perpetrators who commit these heinous acts.
Okay, and Representative Gaines, just to confirm, we're working off of LC 481126, is that correct?
That's right.
Okay, and I apologize, I didn't catch.
Jay Neal, Director of Criminal Justice.
Would you like to
Coordinating
say something?
Thank you, Madam Chair.
Sure.
I really think that Representative Gaines has pretty well covered the intent and what this bill does. We certainly appreciate the First Lady and the tremendous work that she's done. Georgia is recognized around the country as one of the leaders in the fight against human trafficking as a result of the work of the First Lady and the support of the House and the Senate, bipartisan support with her human trafficking issues. I think all of us agree that that the proper steps have been taken through the Survivors First Act and the ability for those who are convicted to apply for vacatur. The issue that this is dealing with is if an individual has taken first offender, they are not considered convicted. So until they complete that first offender sentence, they are not eligible to apply for vacatur. This just makes it clear that they're eligible to apply for vacatur just like anyone else that has been convicted of crimes related to their human trafficking. Still has to go through the same process, still has to go back to the courts and the district attorney. The same process as the others with the Survivors First Act. We just want to include the first offenders in this as well, so they'll have that opportunity before them.
And with this, what's the current situation? Why are they not, or are they eligible for first offender, or are we allowing them to take that even if they have a previous record?
So if an individual, for example, and won't get into any specifics, but an individual that Mr. Atkinson is working with took a plea agreement and in doing so took the first offender, thinking that would be beneficial to her. She is currently incarcerated. Had she not taken the first offender, she would be eligible under First Offender Act to seek vacatur because her crimes clearly are connected to her human trafficking. Because she took first offender, she is not considered convicted. And there is Georgia case law, Davis versus State, that held that a first offender's guilty plea did not constitute a conviction. So she will not be eligible to apply for vacatur until she completes her sentence. Otherwise, she could apply for it now. And that's what this would do, would be allow her the same rights and same opportunities as anyone else that is convicted in a similar situation, having not taken the first offender plea.
Okay, thank you. Any questions? I do not see any questions, and let me just see if anybody signed up to speak on it. I do not see anybody signed up, so I will take up any motions at this time. All right, we have a move to pass House Bill 1201 in a second. Do we have any discussion? Any amendments? All right, all those in favor of passing House Bill 1201, say aye. Aye. Those who oppose, same sign. All right, it passes. Thank you, Representative.
Thank you so much. Really appreciate it.
Representative Holcomb, House Bill 1130. I think it kind of aligns with the same subject, so thank you for being here. Yes.
Sorry, I've been asked to come vote.
Yes, of course. Thank you.
Yes, Madam Chair. Your order is perfect, in fact. The proposal in House Bill 1130 would be to avoid the problem that Chairman Gaines is trying to solve on the back end, which is where victims of human trafficking have been convicted and then there are attempts to vacate that conviction, because just taking a step back, victims of human trafficking are not acting on their own free will. They are subject to being directed by their traffickers. And so the proposal that's before you in House Bill 1130 would be to provide immunity for criminal offenses that are committed as a direct result of being the victim of an offense of trafficking. And that's already in Code Section 16-5-46. So the proposal that you have in front of you would be to make it so that those who are victims would not be prosecuted in the first place. There are 3 experts that are here. I'm not sure that they signed up or knew how to sign up, but with the committee's indulgence, I'd ask if you let them speak if possible, because they bring considerable personal level and substantive level expertise that I think would be helpful.
All right. Let me see if there are any questions. We do not, and they did not sign up, so if you want to call them up, I'd be happy to hear from them.
Thank you, Madam Chair.
Brian, would you like to go first?
And he is from the Wilbanks Child Endangerment and Sexual Exploitation Clinic at the University of Georgia School of Law. There may have been a memo shared with the members that was drafted by them.
Thank you, Madam Chair. My name is Brian Atkinson, and I am the lead attorney at the Wilbanks Child Endangerment and Sexual Exploitation Clinic, the CEASE Clinic at the University of Georgia School of Law. The CEASE Clinic is first of its kind in the nation to represent survivors of sexual abuse, exploitation, and trafficking in a variety of matters, including civil lawsuits against perpetrators, juvenile court, foster care cases, and post-conviction relief matters, where the convictions are the result of or occurred while a person was being trafficked. As an employee of Georgia law, I am not here to endorse or oppose any specific legislation, including any bill on the agenda today. My testimony should not be construed as lobbying. Rather, I'm here to provide information based on my experience and the experience and expertise of CEASE on matters directly related to its work with survivors. Prior to joining CEASE, I was the Chief Assistant DA in Georgia's Northern Circuit, where I served for over 5 years and supervised prosecutions involving crimes against women and children. In 2020, as was talked about in the previous bill, Georgia enacted the Survivors First Act, providing victims of trafficking the ability to petition to vacate their convictions and sentences, so long as the alleged acts underlying that conviction were committed as the direct result of their trafficking victimization. The Survivors First Act, spearheaded by First Lady Marty Kemp, sent a strong message that Georgia is committed to decriminalizing survivors, and instead of prosecuting them, seeking to protect victims and aid in their healing. That law was subsequently amended in order to eliminate the waiting period required for survivors to petition for that relief, so that now a survivor may file that petition as early as after sentencing. So if the state's goals are to decriminalize survivors of trafficking and reserve limited resources in order to prosecute the actual traffickers and buyers rather than their victims, House Bill 1130 provides the General Assembly the opportunity to advance those goals. It allows survivors to seek immunity from prosecution before they're convicted and before they're sentenced, before they start or complete serving their sentence. Because as the law currently stands, those victims who are convicted for acts that were the direct result of them being victimized, them being trafficked, they must first be arrested, likely detained, indicted by grand jury, prosecuted, convicted, sentenced, and then started to serve their sentence or completed serving their sentence. This process is obviously re-traumatizing and directly contradictory to the goals of that Survivors First Act, which is to erase those convictions as if they never existed in the first place. By passing Survivors First, the Assembly recognized those because convictions shouldn't have taken place at all. They shouldn't have occurred at all. And that's where House Bill 1130 can come in. What the immunity process would allow for is that survivor to seek the same ultimate relief, avoiding a conviction, avoiding that sentence, prior to that traumatizing, drawn-out, and expensive process of prosecution. Just to give you an example, one of CEASE's clients had a conviction of a prostitution-related offense over a decade ago. This person went on, left the state of Georgia. This was the only time they'd ever been arrested in their life. Eventually had children, got married, had grandchildren, and ultimately their grandchildren were coming into foster care in the state where they lived. She was told that even though she passed every other measure, the drug screening, the home evaluations, that because of her criminal background check, she could not be considered as a placement resource for her grandchildren, and ultimately they were placed into a stranger's home in foster care. That survivor, like I said, had no other convictions other than the one that was directly related to her being a victim of trafficking a long, long time ago. Because of that survivor's first act, she was able to petition the court and have that conviction vacated, but not until after her grandchildren had been in the state custody and foster care for over a year, torn from their family, when she was willing and otherwise able to have been a placement resource for them, which would have prevented their removal in the first place. Had something like this immunity provision existed, that may have been avoided totally. It's important to recognize the criminal process is not always a quick one, rarely painless, and for survivors of trafficking it can be re-traumatizing. So allowing that survivor to seek that same relief that they are afforded under Survivor's First Act earlier in the process not only seeks to encourage their ability to heal rather than focusing on their court case, but also gets to the same result that they could get to eventually. Did want to note other states have measures similar, either providing affirmative defenses for trafficking or immunity for offenses related to trafficking. And specifically, the affirmative defense states include states like Arkansas and Oklahoma, Wisconsin, and Louisiana, and some other states provide total immunity from prosecution for survivors of trafficking. Thank you for your time. I'm available to answer any questions that you may have.
Thank you. I don't see any questions. Thank you.
And Madam Chair, one other speaker if possible, Susan Coppage, please.
Sure.
Thank you, Madam Chair and Committee, for allowing me to speak today. My name is Susan Coppage, and I was the former Ambassador at Large for the Office to Monitor and Combat Trafficking in Persons at the U.S. State Department. I served under both President Obama and President Trump. I'm a former federal prosecutor who tried trafficking cases and most recently became a defense lawyer for the first time when I took a case of a trafficking survivor who had been prosecuted for crimes that she committed as a direct result of being trafficked. So I'm really honored to be here today to share with you the need for this and to encourage Georgia to continue to lead in the area of anti-trafficking. This is just the next step in that process. We already now address convictions after they've happened. Why should they happen in the first place? Why should we subject the survivor to additional trauma of being incarcerated and prosecuted? Why should we subject the state to a costly prosecution that the law already allows the state to then vacate? So I'm just here to encourage the committee in that area. I earlier saw A.G. Owens here. I think he stepped out. But when I was the ambassador and he was the AG, he asked me to speak to the National Association of Attorneys General in 2015. And in 2015, we were talking about this, and it was called the non-punishment principle. Why do we recognize that trafficking victims are forced to commit crimes, or forced to have sex against their will, or forced to work against their will? Why, 7 years later, 8 years later, I'm a bad mathematician, I'm a good lawyer. Why are we still prosecuting trafficking victims? And this law would give them the opportunity to raise this immunity from the beginning of the process. So thank you so much for allowing me to express that personal interest and also professional interest today.
Great. Thank you so much for being here. Okay. Do you have anybody else, Representative?
No,
okay.
Thank you.
Thank you. Any further questions? I will take up a motion at this time. Representative Crowe.
Thank you. Just a quick question. Sure. Thank you for bringing this bill. There's no specific crimes that are excluded under this. Is that correct?
That's correct.
So it could be anything, but it does have to go through a hearing, and the burden is on the defendant or the trafficked person to prove that the crime was a direct result
That's exactly
of the trafficking. Am I reading that right?
Yes, sir.
Okay.
That's exactly right. And I think the other thing that I'll offer for y'all's consideration, consistent with the expert testimony that you heard, is not only do we want to prevent a victim of trafficking from going from the criminal process, I actually think by having this step at the beginning, we'll be able to identify and then prosecute traffickers sooner and faster, because this will provide an architecture for that to happen.
Great, thank you. All right, any motion? All right, we have a motion to pass and a second on House Bill 1130. Any amendments? Any discussion? All right, all those in favor of passing House Bill 1130, say aye. Those who oppose, same sign. All right, passes. Thank you. All right, Representative Cameron.
Again, my apologies.
No, thank you. You made it right on time. House Bill 590.
Thank you, Madam Chairman. Good afternoon, committee. I found out that there was a request for an addition to this bill that you passed out of committee recently. So what it was prosecuting counsel Smith asked that a venue clause be put in this bill about how it be prosecuted. So I have proposed language from the Attorney General's office if the committee so chooses.
Okay, so can you give us, is it LC 365532?
Yes.
Is what we're looking at?
Because I hadn't had time to make any changes since this morning.
Okay, and again, for just to make sure, we already heard this in my subcommittee before we passed it out, but there were some language that needed to be added, so that's why we brought it back. And so can you point to us, or are you saying that it's not in here?
It's not in there.
Okay.
Mr. Smith wanted a venue clause in the bill that's not in there now about how it would be prosecuted.
Okay.
Where it would be prosecuted.
Robert, is he in here? Robert Smith, would you come up here real quick, please, and tell us what that language will be?
Sorry. That's no problem. No problem. Basically, the question was where they wanted this crime being prosecuted at. Did you? And that was the whole question and the hold up on it. And the language that the sponsor has got in front of me reads: in a proceeding under this article, the crime will be considered to have been committed in any county where the person whose identifying information was published resides or is found, or in any county in which any other part of the offense took place, regardless of whether the defendant was ever actually in such county. That's a venue provision that's been lifted, and I think it's the one that got passed a year or two ago about currency transactions involving elders. So it's something that what this allows is that the victim. So in this case, we're talking about officers who have their personal information put on the websites. It allows rather than the officer having to go find the person who put up the website or the person who put that information out, the officer can go to his local sheriff's office, his local police department, file a report, and then it's referred to the local district attorney or the local solicitor to prosecute the case there. Or if they want to, they could go somewhere else where somebody viewed it and misused the information. But this allows the prosecution to be where the victim's found.
Okay, thank you for that clarification. Any questions? Representative Crowe?
Where would that go in this? Would that be paragraph D?
Yeah, see that for a second.
Still in section 1 after line 30?
You've got a very fine legislative counsel over here, so I don't want to overstep.
Yeah, I mean, that question is to whoever wants to answer it.
I would suggest that we could go there, wherever you feel it's artful to go.
Okay.
Oh, what number are you? Okay. Go ahead.
Legislative counsel, I would put it as subsection D at the end of the statute. That's where it should go.
Okay. Madam Chair, if you want me to, do you want that to be written as an amendment?
Yes, at the right time.
Okay.
Do you have any other questions?
No, ma'am.
All right. Representative Miller? Oh, I'm sorry.
I'll do that for you.
Anybody?
Madam Chair, can I pass out on behalf of the member?
Sure. Representative Roberts, or is there anybody over there? Okay. Oh, I'm sorry, Representative. not used to this room. I apologize. I'm just used to one row, not two. Representative Byrd.
Thank you, Madam Chair. Thank you, Representative Cameron. I'm trying to understand, this is strictly for peace officers?
This is specifically for peace officers, and it emanated from last year's attack on the training center site. Someone set up a website out of the country, actually, Cop City Cops. They placed information on approximately 1,900 peace officers in Georgia. The information about their families, it could be pictures, pictures of their children, those kind of things. And so that's where the bill emanated, so that we could prosecute people that do that and put our peace officers at risk. And so it was narrowly focused on just this.
So if there's a lot of terror that goes on from out of this country, so if something is done by people out there in the outer world and they provide information of peace officers and their families, how do we go about convicting them? Or,
well,
sorry, I can't.
No, that's okay. I think from last time we said that the Attorney General's office, they could use this legislation as a tool to work with federal partners or whoever to go after these people. But the framework is this to be able to do that. So
but that's only if they, I mean, is it in this country or going outside the country? Or, I mean,
we could use our partners at the federal level to go, work with other people to bring these people to justice.
Okay, thank you.
Same as child pornographers.
Okay.
Can you say that again?
It's the same as child pornographers. We can basically we work, the DAs and the Attorney General work with federal as well as state partners, and if we can find the people responsible, we will take the steps we need to protect our victims.
And essentially, Representative Byrd's concerns, as far as including this venue language, is so that we're not just trying to chase somebody everywhere. Is that correct?
Yes, ma'am.
Okay.
That's the whole purpose of why adding this in. Then instead of having us, say you've got somebody who's being a bad actor and they're in another country, rather than us having to go to the other country to prosecute them, we can say this officer lived in Cherokee County. The Cherokee County DA's office is the one who's going to prosecute it, because the Cherokee County Sheriff's Office, working with the GBI, working with the FBI, working with Interpol, brought this person to justice.
All right. Sure, go ahead.
Sorry. So with the peace officers, but what about, I'm always thinking this in terms of, we are certainly, I wholeheartedly support peace officers and public safety and all those types of people and protecting them, but there's a lot of other people that need protection as well. So we're just taking individuals and protecting them.
But there was a sense of urgency because of what happened at the training site, and the subsequent things that happened to some of our peace officers, to protect them first. Yeah, I think there was testimony from the Defense Council people that we'd like to see that broadened eventually to everybody to do that. But for right now, the most immediate is this.
All right. Representative Roberts or Miller?
Me. I'm sorry, I'm 10. Thank you. My colleague and I were just discussing, and I just wanted to clarify, I think I know what the answer to this is, but I just want to make sure we're reading it correctly. We define personal information to mean all kinds of things, including the name of the police officer. Oftentimes we will see in cases of significant public concern, like police brutality cases, for example, protests will erupt about that, and the public will want to make, the protesters or activists want to make the public aware of the officer, of the killing, the officer's history, things like that. Under your bill, that would not be a problem. It would only be a problem if there was a threat of violence associated with the publishing of the officer's name, for example?
Yeah, with malice, I guess you would say with malice. They did it with malice. With any threat or suggestion of a request for physical injury, serious physical harm, or violence against the peace officer.
Okay, so it's publishing that personal information with a threat of violence
Yeah.
or to do
Or the
harm to the
intent,
police
yeah.
officer.
Yes.
Okay, thank you.
Thank you. Question.
All right, that's all the questions, and I believe we have one person signed up to speak, so I'll call
Thank you.
on James Woodall.
Thank you, Madam Chair, and I think Thomas Weaver also wanted to speak to this as well, if you would recognize him after. But James Woodall from the Southern Center for Human Rights, and I rise today in opposition of 590, and I first want to give thanks to our First Amendment fellow, Suad Abdel Aziz, who really did a remarkable job in analyzing this legislation. But we have really three issues with this legislation. One, which is the infringement on the First Amendment because of its vague and overbroad nature, as well as punishing protesters. And so I want to begin with Section 1A3. While intending to threaten, suggest, or request violence of any kind, the intent that's required in that legislation, however, is not necessary to establish by the writing that issue. And so the intent element of this crime, as contextualized both by the language in the bill as well as the testimony we've heard both today and last time, was overbroad and could punish individuals for merely expressing anti-government animus online. In the testimony specifically on January 29th, the Deputy Attorney General Fowler cited the copsofcopcity.noblogs.org website, which archives publicly available information. There is no notable threats nor encouragements of acts of violence. Nevertheless, there was an offering that the website's content alone would be sufficient to pursue prosecution pursuant to this bill, which would then enable prosecutors to gather additional corroborating evidence. If his analysis is correct, this legislation as written would grant the state the power to arrest before establishing probable cause for intent. Moreover, this bill does violate Counterman versus Colorado. And in that decision, the court held that, one, the First Amendment requires proof in a criminal action regarding a true threat that the defendant had some subjective understanding of the threatening nature of his statements, as well as, two, the recklessness and the appropriate mens rea consistent with the First Amendment for a criminal conviction for communicating constituting a true threat. This case law stands for the proposition that in true threat cases, the First Amendment requires the government to prove that indeed the defendant acted with a culpable mental state and not just merely that his words or her words were objectively threatening. This is in contradiction to the Attorney General's statements that an objective implication of violence is not protected by the First Amendment. And that vague intent element of this proposal could result in a threat to the First Amendment protection set out in Counterman. This bill also addresses conduct that's already expressively protected or criminalized rather in the code, and then it also unnecessarily specializes the category and fails to promote public safety because of the reasons in which Representative Miller has raised. Again, we believe, one, this does violate the Constitution, which is outlined in Counterman v. Colorado. We think it is redundant in that all the conduct that we see addressed in the bill is already protected in the code, or criminalized rather in the code, and then it just creates an unnecessary specialized category of peace officers and doesn't render the entire public safe from this behavior. With that, Madam Chair, I'll stand for any questions if there are any.
I don't see any. Thank you.
Thank you.
Mr. Weaver, would you like to speak on this? I'll give you time.
Thank you, Madam Chair, for recognizing me to speak, and please excuse my faux pas, members of the committee. I neglected to sign the number for this one on the sign-up sheet. But thank you, Madam Chair. I just want to echo the sentiments that was shared by the gentleman. The 7-2 concurrence, citation 600 U.S. 66, I believe, for the Counterman v. Colorado decision that was rendered by the Supreme Court last summer, had some unlikely bedfellows. Kavanaugh and Gorsuch joined. And Alito, strict conservative-minded justices, unlikely bedfellows, to join in with the respectful opposition there to say that the First Amendment's protections cover even speech that's maybe socially unacceptable, but that's not you know, I don't take an issue with it one way or the other. I'm just, don't shoot the messenger. That's what the Supreme Court said, and the burden is on the government. The other thing, in respectful approbation of the sentiments that was raised by the representative, when we, as a legislative body, when the General Assembly starts to carve out a protected class, a holier than thou, certain people are elevated higher for want of statutory protection. I understand the alleged legitimacy of why that's required, and certainly there's a bevy and plethora, a cornucopia of other statutes that do just that with judges and prosecutors and police and the like. But in approbation of her remarks, not mine, it just invites serious conversation. Is if you continue to do this, you start to create a different class of people who have. It starts to get into equal protection of the law issues. But I'm not going to go too far down that road. I can understand the desire behind it, but it's a sentiment that needs to be thoroughly vetted, and that would be my hope that in considering the Counterman v. Colorado case, that there might be enough of a brake pedal there. But thank you, Madam Chair.
Thank you. All right, I believe that's everybody signed up. Would you like to say any response? You don't have to if you don't want to,
Okay.
but it's fine. I'd always like to give our sponsors a moment to respond after.
As Polonius once said, brevity is the soul of wit.
That's right, I agree.
Coming from a Northwest Georgia hillbilly.
All right, then I'll take up any motions at this time. All right, we have a motion and a second. Do we have any amendments? Representative Crowe?
All right, as previously discussed, on what would be after line 30, we would create a section D, in which would state the language we've been given printed here. Do you want me to read that language for the record?
Sure, yes.
Okay. We'll add a paragraph D, which will state, in a proceeding under this article, the crime will be considered to have been committed in any county where the person whose identifying information was published resides or is found, or in any county in which any other part of the offense took place, regardless of whether the defendant was ever actually in such county. And that would be my amendment.
Okay, so we have been offered amendment. Do we have a second on the amendment? Okay. All right, we'll vote on the amendment that Representative Crowe just stated. All those in favor of Representative Crowe's amendment, say aye. Aye. Are those who oppose, same sign? All right, so the amendment is adopted. And on the underlying motion with the amendment on House Bill 590, all those in favor of House Bill 590 with the amendment, say aye. Aye. Those who oppose? No. All right, and it passes. Thank you.
Madam Chairman, would I work with your council to make it, or go back to the original council, the legislative council, to add this?
Legislative Council.
Gonna do-
Well, that's right. I'll let you take that up with Legislative Council. Thank you.
Thank you very much.
All right, Representative Reeves on House Bill 446. All right, Representative Reeves,
Good
go ahead.
afternoon, Chairwoman Hong and members of the subcommittee. I'm here to present House Bill 446, the drive-by shooting bill. I have with me Brandon Delfont, a former high-ranking assistant district attorney with the Gwinnett County DA's office, as well as Tyler Lee, who is a public safety advocate in the Peachtree Ridge area in my district, here to speak after I present the bill, and I thank them for their work on this. I will be brief. because we spent some time on this last year. It got passed right before crossover day to Rules Committee and got there a little bit too late. I've continued to work with prosecutors and criminal defense lawyers on this important bill. But this bill came about because Mr. Delfont and a Superior Court judge in Gwinnett County saw a need to provide greater specificity to Georgia's drive-by shooting law to make sure that there's no confusion on jury duty that would impede review of these heinous crimes during the process. So Mr. Delfont will talk a little bit more about his experience and the need for the legislation. But let me walk through the specifics of the bill, because this is somewhat more streamlined and succinct from what you saw last year. So in the words of Thomas Jefferson, if you give us more time, we can make it shorter, and we did that in this case. So Section 1 pertains to aggravated assault, and it adds some specificity in subsection 4 of that statute, where if someone is in a motor vehicle or immediately exiting that vehicle and they fire towards a person in an occupied motor vehicle, an occupied building, a motor vehicle or a building that the defendant knew or should have known was occupied, that is a specific drive-by shooting offense under aggravated assault. Section 2 is the criminal damage to property statute, and we added knowingly and without justification cause damage to a building by discharging a firearm inside the vehicle or immediately after exiting the vehicle. And we do have an amendment that I thank the criminal defense lawyers for pointing out today. I believe Representative Crowe has it. I have copies of it. I'll pass it out. And we are proposing to change the 5-year provision in line 38 to 2 years. So that would line up with the criminal damage to utility property that we passed last year. Section 3 is Section 3 and 4 gets into the gang and RICO statutes, and this is where we get more into firing at a home or a dwelling, and that just provides some specificity here. At that point, or at this point, since it's late in the day, I will yield for questions or turn it over to Mr. Delfont to talk about his experience that got me working on this bill. And I would also mention the majority leader. I met him when he was a Gwinnett County Assistant DA, and he is the one who heard originally from Mr. Delfont and Judge Warren Davis in Gwinnett. So appreciate his highlighting this need also.
Sure, thank you. And we can hear from Mr. Delfont. Thank you for being here.
Oh, thank you, Chairwoman. Can everybody hear me? All right. So I spent about 12 years as a prosecutor, first in Cherokee County, and then finally for the last 7 years in Gwinnett County. I was the Deputy Chief Assistant District Attorney there, and one of my roles was to supervise the Drug and Gang Task Force, which was tasked with handling all gang crimes. Myself, I've prosecuted well over 1,000 gang crimes in my career, and many of those involve drive-by shootings. In fact, I wrote a letter that I think Representative Reeves gave to the committee, and in there I discussed that at one point in 2021, when I was documenting statistics of the number of drive-by shootings in Gwinnett County alone, the average was coming out to about 1 per day in Gwinnett, and that's just in Gwinnett County. It tends to be, drive-by shootings tend to be a very common mechanism by which gang members exact revenge and commit violence because it's easy, right? You can just get in a car and drive by a home, and unfortunately, a lot of people have died and gotten injured and killed as a result of it. But it's not even so much just the intended person, the intended victim, but when somebody's driving down the road at high speeds, or they stop and they're sitting in a vehicle or getting right out of the vehicle and opening fire, they're hitting indiscriminately other homes, cars, and regularly we would find many unintended victims of a drive-by shooting. The current legislation, which is the aggravated assault statute, which is OCGA 16-5-21, subsection 4 does address drive-by shootings. It does provide a mechanism by which we can prosecute and have prosecuted successfully drive-by shootings, but it's limited. It requires that it only criminalizes when somebody is inside of a motor vehicle and shoots at another person. And that's the extent of that particular subsection and provision of drive-by shootings. The proposal in this legislation expands that. And practically, the reason that we talked with Majority Leader Efstration and Representative Reeves was because so many instances of actual violence in Gwinnett County, what would occur is somebody would drive up to a home, and one of two things would happen. Either they would fire at the home, but nobody's home because it's late at night and they're just wrong about whether or not their intended victim is home. And that happened more times than I care to count. It was property damage, essentially, because nobody's in the house. It can't be prosecuted under the aggravated assault statute because nobody's inside the house. It doesn't qualify. Or they'll get out of the car so that they can get a better vantage point on shooting at the house. And again, if nobody's inside the house, it's not aggravated assault. It is simply a property crime. If somebody is in the house and they shoot at that person, it could qualify as aggravated assault under a different subsection of aggravated assault. But this bill and the need for it was to criminalize the act of the person who is intending to commit violence. Essentially, the only difference between prosecuting somebody for aggravated assault when they shot at somebody who was actually in the home or at somebody in particular, or an unoccupied dwelling, is the disparity in punishment was significant. Because at best, we might be able to charge them with a weapons offense and maybe criminal damage to property in the second degree. And those together are still less than the offense for aggravated assault in the statute. And so this provides a mechanism by which to punish the person who's actually intending to kill somebody. And the only reason they may not have done so is that they're just wrong about whether somebody's in the house or not. And also, we also found a lot of problems with proof of intent. When they would go and open fire and hit other buildings or other vehicles, not the intended target, but just they would spray bullets and it would hit random homes and things like that. They didn't intend to shoot that home. They intended to shoot the particular home they shot at. They just missed or cast a wider than normal net. And unfortunately, there was issues with intent there that defense attorneys would raise. I am now a criminal defense attorney, and so I may regret all of this soon enough. But the reality is that the legislation is necessary, in my opinion, because we just found such a disparity on the ability to prosecute people who were committing the exact same acts, but yet we're seeing significantly different outcomes. And I mentioned in the letter, it's probably worth mentioning here as well, that the majority of the people who are committing these crimes, at least in Gwinnett County when we did the documentation, personally, well over 90% of the drive-by shootings committed in Gwinnett County were committed by members of criminal street gangs. Georgia-wide, I don't have the number. I did speak to the executive director of the Georgia Gang Investigators Association. He mentioned that he would put it somewhere at 85 to 90% of people who are members of criminal street gangs. So these are the bad actors, and yet those bad actors are getting significantly less punishment simply because they got out of the vehicle, or because they hit the wrong residence, or because they hit a house that wasn't occupied at all. This legislation seeks to correct that. It also provides an amendment to OCGA 16.7-22, which is the criminal damage to property in the first degree. That is not, we can't charge most of the time a drive-by shooting under that statute because it requires something that's dangerous to persons. And if no one's in the building, it's not really dangerous to persons if it's an unoccupied structure or no one's home. So this allows for that property damage to also be charged as criminal damage to property in the first, rather than potentially criminal damage to property in the second.
All right, Mr. Tyler Lee.
All right, thank you, Madam Chair and members of the State House Judiciary Non-Civil Committee. I'm here today to speak in favor of House Bill 446, the drive-by shooting bill, authored by an upstanding community leader that I'm proud to call an ally, Representative Matt Reeves, who also happens to be my legislator in the State House. And so I'm currently a junior at Peachtree Ridge High School, just celebrated my 17th birthday, and a lot of people have asked, don't you have anything better to do as a teenager? But I believe that I'm here for a good, upstanding reason, in keeping not only myself, but my peers safe in our communities. I'm proud to serve on our student council as an elected member and a campaign operative to many candidates seeking office in Gwinnett County. During my advocacy for firearm safety and public safety. I've met with police chiefs for the city of Lawrenceville, the city of Duluth, many of the lawmakers, I believe almost entirely the Gwinnett delegation, and prosecutors and county officials in pursuit of addressing this plague. And I've learned a lot in this endeavor. 2 years ago, I took up this type of advocacy after what we saw in Uvalde, Texas, and I've since been published in the Atlanta Journal-Constitution, the Gwinnett Daily Post. I've been videoed by Fox 5 News, Channel 2 Action News, and 11 Alive News as I advocate in my community. This epidemic of drive-by shootings and gun violence in general, a lot of the brunt is bared by young people in Gwinnett and in the state of Georgia. And I find it my responsibility to advocate on the behalf of young people in this state because of the violence that is carried out by irresponsible and reckless people that decide to use firearms to perpetrate this type of violence. In many of the gun violence-related crimes committed in Gwinnett and in the state of Georgia, the operation of a firearm in a moving or stationary motor vehicle proves to be most popular, as Mr. Delfont expanded on. And the crafting of this bill, as I've been informed, it's been a robust and dynamic discussion among many different attorney groups. And I really do thank Mr. Delfont and his counsel to Representative Reeves as his acumen on the judicial system and this bill's pertinence to it is very unmatched. House Bill 446 is designed to keep our communities safe as this type of crime, violent crime, rises in prevalence. In Gwinnett County, drive-by shootings and specifically the road rage incidents that precede this are very commonplace. We're seeing that a lot in which people are unable to control themselves in traffic. You know, I get it. I was driving down the highway getting here, but there's no reason to pull a firearm and enact this type of violence. And so the enhanced penalties put in place through this legislation, as well as the clarification of multiple criminal statutes, will go, without a doubt, a long way in assisting prosecutors and police in going after criminals who seek to harm members of our community. And I'd just like to speak on an incident that took place yesterday. Just yesterday, we saw 4 students at Benjamin E. Mays High School that were victims of this type of crime, a drive-by shooting. The news cycle is still covering this incident because it is so recent. And as of now, I'm asking the legislature and this State House committee to take action to ensure that students, young people, and the citizens of Georgia are safe from this type of crime. Thank you.
Well, I don't believe that you're in high school. That was very good. Very impressive. Thank you for being so interested in this and very well spoken. Thank you.
Thank you. And if I may, I believe you know my mother.
Oh, really? Okay.
Queena.
Are we friends? Am I friends with your mom? Probably.
Queena.
Okay.
And so.
Oh, yes.
Yeah.
Okay. Yeah, I think we are actually friends. Yes. Thank you. All right. We have one question. Representative Crowe. You'll wait? Okay. All right. Representative Byrd.
Thank you, Madam Chair. I'm full of questions today. Thank you for the presentation. So with all the drive-by shootings that are happening in and around Gwinnett and every place else, how many are caught? Is there some sort of statistic of people when you're in a car, you're driving by, you're shooting at someone's house? So that's my first question. I mean, when they're driving by, does someone else see their license and they report them and then they go get picked up? And is this going to really stop drive-by shootings if we do another law?
I'll start out and then would defer to Mr. Delfont and his experience. One good thing about the million-person county of Gwinnett County is we've got 15 or 16 or so cities, and we've got a Gwinnett County police force, and they are good about using technology to solve crime, and so flock cameras are very abundant across Gwinnett. So if somebody is, wanton and reckless enough to go do a drive-by shooting in Gwinnett, just let the word get out. We're going to see your license plate and your description and all that and hunt you down if you do that in Duluth or Suwanee or, Central Precinct in Gwinnett. In all likelihood, you are going to get caught. I've heard from Northside, Lawrenceville, that they have a lot of the victims of these, one a day statistic Mr. Delfutt mentioned. And so, you've got immediate police and medical attention that hopefully will help those people with, getting the descriptions and all the law enforcement tools to find them. And with that, I'll defer to Mr. Delfutt. But a lot of them are caught, but the judge and Mr. Delfutt, they wanted to iron out Georgia drive-by shooting law so that they're convicted and there's no confusion in the jury about the crimes.
So I guess with any crime, there's a lot that doesn't get prosecuted. There are not a lot of people who don't get caught. For the 365 reported just a few years ago, there are more that were never reported. If nobody's in the home or they just don't realize their house got struck, they may not report it and may not know when it ever happened. And so of the reported ones that we have, a large number are caught, but there are many that aren't caught. It can be difficult depending on what part of the county and whether there are cameras around, whether there is technology that was able to. Most of the time with the gang-related offenses, the investigators with Gwinnett Police and the municipalities are able to locate very quickly the gang that's responsible because it tends to be some kind of turf warfare or some kind of vendetta that can be fairly identifiable. But to maybe answer your question a different way, in another case that I had dealing with drug distribution, there was an individual in DeKalb County who was selling fentanyl and resulted in 2 people's deaths in Gwinnett County. And our investigators set up undercover operations with him to purchase amounts of drugs so that we could ultimately charge him with murder in Gwinnett, which we ultimately did. However, in the entire process of the undercover operation, we had recorded phone calls with him, and he would repeatedly say, "I'm not coming to Gwinnett County. You can forget it. I'm not coming to sell you anything in Gwinnett County because they will send me to prison for life." Right? Now, it's not always the best thing to have a reputation that you punish everybody to the maximum thing, but at the same time, whenever you combat and specifically target a particular type of crime and let the community know that you're not going to stand for it, that you're going to aggressively combat it, it does impact the ability or the desire that criminals have to do something that they know may ultimately cost them more than they bargained for.
All right, thank you. I think that's all the questions that we have, and we have several people signed up, so I'm going to start calling on them. Maisie Lynn, did she come back? I don't think so. All right. Let me see. I'm going to do Robert Smith. Did he come back? Did he leave? We're losing everybody. All right. And Thomas Weaver.
Thank you, Madam Chair, for recognizing me to speak on third occasion. Members of the committee, let me be clear. The governing majority has made it a very clear public policy stance by and through the efforts of our governor and others that criminal street gang activity will not be tolerated and its days are numbered here in Georgia. And to the respectful opposition or any member of the respectful opposition party that may be in the room, I know that your party's taken a platform that pretty much more or less sick and tired of gun violence, and you would like to do anything you can about it any way you can. I would like to repeat a sentiment that was shared by Representative Byrd on second occasion, like I did in an earlier statement. There are a bevy of laws that combat gun violence in Georgia. In fact, minimum periods for confinement, Georgia Code Section 1611-133. If a criminal offender is a convicted felon and they use a firearm a second time to perpetuate another felony firearm offense against a person, that's a mandated life imprisonment statute. We're piling on code section on top of code sections to criminalize and then recriminalize the same thing. Case in point, one statute that was neglected to be mentioned by the proponent testimony of the author's legislative proposal, the proponents neglected to mention the terroristic acts statute. Georgia Code Section 16-11-37, subsection C, paragraph 2, provides for the offense of shooting at a motor vehicle that is occupied by persons. Doesn't speak to building, but it does speak to vehicles. So you are recriminalizing something in part that's already crime, and if you don't address that, then that could potentially create rule of lenity issues before the appellate courts, because you have two statutes that both prescribe for the same prohibited conduct. However, one statute now would have a lesser penalty, so a defendant might, through skilled counsel, argue to be given that lesser penalty under the rule of lenity. And as a result of that, it would undermine the enhanced penalties that the author is trying to create by clarifying the crime in part if the object of the defendant's behavior happens to be a motor vehicle that is struck. And saying that too, I want to bring about another fact that was pointed out based on the $500 threshold. Yes, under current Georgia law, it's a felony to damage someone's property in excess of $500, but it's a criminal trespass if it's less than $500. On that second criminal trespass, that's a no bail if the governor signs that bill. So at that point, that offender would no longer be on the street unless somebody put cold hard cash on the table to get them out. So I just think that the legislature's laudable goal through the governing majority's major public policy viewpoint to crack down on criminal street gangs is admirable, and to the respectful opposition to do something that you legally can within the ramifications of the Constitution and the law about gun violence where possible. That's admirable. I've seen some of the videos that were released by WSB-TV and Fox 5 about some of the shootings that occurred. It's horrific to watch. It's not okay. Normal, sane, sober, reasonable, rational people don't behave that way to communicate an idea or to convey a point. There's more than one way to do that. It's horrible and it's not acceptable. And I agree with the author. Something should be done to make it clear that that behavior is not going to be tolerated in Georgia. But when you look at the law as it sits today, possession of a firearm by a convicted felon, possession during the commission of a felony, aggravated assault, terroristic acts, discharging a firearm in a public place, discharging a firearm within 150 feet of the road, criminal trespassing, criminal damage to property in the second degree, now criminal damage to property in the first degree if this legislative measure should meet with the General Assembly's approval for enrollment and gubernatorial ratification, along with the sentiments espoused through the procreation of yet another statute, as if the General Assembly wasn't clear enough, the 16-15-4.1. I think we're beating a horse to death here on something that's already a crime and that punishment is in effect. And if the rule of lenity issue isn't addressed in respect to the motor vehicle portion of it, I think that might be problematic and an appeal if that happens to be the exact facts of a particular case. And to substantiate that point, Madam Chair, if the chair should choose to allow it and the committee is amenable to it, I would like to present the committee with proof of that by presenting the committee with the actual current present rendition of the official code of Georgia, annotated current through the most recent code revisor committee from last year that shows through the highlighted portions that there is in effect today a portion of a law in a different part of the code that actually criminalizes that underlining act.
Can you just reference that?
Absolutely, Madam Chair. It's Georgia Code Section 16-11-37, subsection C, paragraph 2. It, again, to be clear to the Madam Chair and each member of the committee, it speaks to vehicle. It doesn't speak to building. So the author's bill would accomplish something that 1611-37 does not in its present rendition. But to say that there's not enough and we need more, I'm sympathetic to the plight of the author and his proponent testigants. I agree something needs to be done to make it clear that this is not acceptable. But the General Assembly should take these technical, legal considerations and place them in the limelight and not just railroad over them in order to ensure that the final legislative product is something that would leverage merit before the judicature if challenged.
Thank you. Robert Smith, would you like to speak on it.
Apologies, I was outside in the hallway. This bill's been vetted and been discussed at great length. Mr. Weaver is right about the conveyance, because that's what the terroristic acts reads, that when you throw an object or shoot at a conveyance that is being operated, argument can be made in court that there's an intent that the legislature meant to do something different. So that's one. There is a potential conflict, yes, but at the same time, because the language is not the same in both, and because would be an argument there's a different element and different things, different standards of proof, then I think we would. That's one of my burdens, something I would have to argue and something that I would have to prove. Whereas someone like Mr. Delfont would be arguing on the other side, adopting Mr. Weaver's argument that this law is horribly wrong, horribly drafted, and is unconstitutional, or at the very least, the rule of leniency should allow his client to get a misdemeanor or 1 to 10 felony. Otherwise, that's, and by the way, Mr. Delfont is a good friend, so that was kind of a little bit of a poke at him and the fact that he's wandered away from us briefly to expand his horizons. But other than that, that's essentially my remarks on this.
Thank you.
I'll stand for questions if anybody has any.
No questions. Thank you. Maisie Lynn?
Thank you so much. Maisie Lynn Gerton, I'm the Executive Director of the Georgia Association of Criminal Defense Lawyers. I did not get to hear all that's gone before me, but it sounds like you've got some issues to consider. I would like for you to know that I've been in conversation with Chairman Reeves really since last session on this bill. Our organization has, and we've gone back and forth and feel like some of the narrowing that's occurred has just made the bill much better than it was. There's one more additional friendly amendment I discussed with him this morning that I believe he is open to considering. And in particular, that would be to modify the sentencing scheme that's laid out on lines 33 through 38. Specifically, and the rationale is this: when you look at that whole, beginning at lines 24 all the way to 38, when you look at the types of criminal damage to property that we are now considering in subsection B, B1 has this sense of endangering human life there at line 27. B2 has interference with critical infrastructure, so these kind of higher level, if you will, impacts, versus damage to a building, which I realize can be quite substantial, but it could also be a nick in a wall. And so we discussed the possibility of bringing the sentencing for the new B3 in line with B2, which I believe could be accomplished by inserting on line 35 the word or, and then the number parenthetical 3 after paragraph 2 and before of subsection B, and then removing the enhanced punishment going forward after a second or subsequent violation, beginning at line 37 after years, just removing the rest of line 37 and 38. And so if that is something that Representative Reeves is ready to go, willing to accept, I would just put that forward.
Thank you. Any questions? We don't have any questions. Thank you.
Thank you.
Thank you, Representative Reeves, for bringing this. We're going to keep this as a hearing only today. Thank you for the conversation. And if you want to stay there, we'll take up your next bill, which is House Bill 656. Thank you both for being here. Thank you. Say hi to your mom. All right, whenever you're ready.
Chairwoman Hong and members of the committee, I present to you House Bill 656. This is a much longer distance bill than the one you just saw. This one came from Thomasville, Georgia, Representative Darlene Taylor and Police Sergeant Adam Lawson from the Thomasville Police Department. This bill was pending last year, and I've worked with the prosecutors and criminal defense lawyers to revise this bill. Additionally, I heard from Georgia advocates for domestic violence victims, and I believe they are present today for any questions for them, and they may want to speak to the bill. But we have revised this bill to make sure it protects children and victims and doesn't unwittingly get domestic violence victims sucked into the scope of this bill. But there is a letter from Sergeant Lawson that is attached to the bill, and we're working on LC 48-1198S. And in that letter, Sergeant Lawson gives the history on this legislative initiative. He has found multiple instances in his area where a child does not experience physical violence, a child does not actually ingest drugs, but there are drugs all around that child. That child is in, mortal danger with having drugs all around, and that child experiences mental trauma that's going to be, permanently damaging to that child. And this bill is designed to criminalize perpetrators putting children in that danger of having, dangerous drugs around them. Marijuana was excluded from this bill to stay away from that hot topic, but illegal drugs and then traumatic situations, including family violence and other violence occurring around that child. What this says is if you're the predominant aggressor on a forcible felony, acts of violence around that child, you're going to get punished even if you don't physically hurt that child. Additionally, in lines 15 through 17, that's the provision in there about having illegal drugs other than marijuana around that child. The second part of the bill, and again, this was coming from Southwest Georgia on the Florida border, Sergeant Lawson learned that both Florida and Alabama have enacted laws that say if you travel to the state for the purpose of committing indecent acts with a child, that's a crime. Right now in Georgia, if the perpetrator does not consummate the act of molesting that child, does not actually, lay hands on that child, then the authorities can't really do anything in the way of charging that individual. You have to basically catch the person in the act of molesting that child. This law says if you cross state lines to come to Georgia to solicit, entice, commit, or attempt to commit any act of child molestation or other indecent act, and then lines 51 and 61 go through additional conduct, then that itself is a crime. What Sergeant Lawson and Representative Taylor and I are asking you to do is to add these things that will protect children from, mortal danger and permanent damage and injury of, having drugs all around them or traumatic violence around them. And then secondly, to tell child molesters from Florida, Georgia, South Carolina, Tennessee, don't come to Georgia to molest a child, because gone are the days where the police have to catch you in the act for that to be a crime. We're going to do what other states have done and protect the kids to prevent people from coming to the state to molest kids. So with that, I would be glad to answer questions about the bill and just commend Sergeant Lawson's detailed letter to you and think through. Georgia's the largest state geographically east of the Mississippi. We've got a lot of borders with those border states. Other states have acted in this area, and I would ask you to help Georgia do the same for the children.
All right, thank you, Representative. I don't see any questions, but I have several people signed up. Karina Dillard. I hope I said that right. Dillard? Oh, yep, okay, great. Sorry, I couldn't read the first name. But if you can introduce yourself and...
Thank you so much, Madam Chair and members of the subcommittee. My name is Karima Dillard, and I am the Director of Policy for the Georgia Coalition Against Domestic Violence. And I'd like to recognize my personal legislator, Representative Miller. Hello. So we are a member-based coalition, and we consist of domestic violence programs from all across the state of Georgia. And I just want to start out by saying a deep, deep, deep thank you to Representative Reeves for being so compassionate and so responsive to our initial concerns about HB 656. The revisions that have been submitted definitely don't remove the possibility of dual arrest of domestic violence victims, but it does go a long way in reducing that likelihood. Earlier today, Ambassador Coppage said, "Why are we still prosecuting survivors?" And even though she was referencing trafficking survivors, the very same thing can be said about domestic violence survivors. And I argued that, in part, one of the reasons we're still prosecuting survivors is because of unintended consequences of well-intended laws. And this is one of those bills that was very well intended to protect children from experiencing trauma. We know all about adverse childhood experiences and the long-term implications of social emotional development. It's been well documented. But what's also been well documented is the intersection between domestic violence and child welfare. And so many victims of domestic violence are misidentified as perpetrators. The children are removed from protective parents. It happens all the time. And Chairman Reeves has just done such a wonderful job of trying to put guardrails around the language to make sure that victims are not harmed, and we just appreciate that so much. The last thing I'd like to say is that victims of domestic violence are often asked, "Why didn't you leave?" And I think that people really miss the egregiousness and the insidiousness of domestic violence and how it exists beyond physical bruising that you may see. We're talking about psychological terrorism, financial abuse, emotional abuse, sexual abuse. It goes on. And there are so many reasons why a survivor doesn't leave. But the Georgia Commission on Family Violence found that the most dangerous time for a survivor is when they decide to leave a relationship. So if someone were to try and argue that a victim of domestic violence should be charged with cruelty to children in the second degree because, they've been experiencing domestic violence for a long time and exposing the child to domestic violence for a long time, and they should have just left, don't understand how power and control work in domestic violence relationships. So again, we appreciate Representative Reeves for understanding that and being so compassionate and responsive in making sure that we're protecting victims of violence. Thank you so much for your time.
Great, thank you.
One thing, Ms. Dillard and her representatives asked one revision that we made on line 13, add back in the word criminal. So it would read with criminal negligence. And I ran that by the prosecutors, criminal defense lawyers, and that's one amendment I would like to request on LC 481198S.
All right, thank you. Ellie Williams?
Thank you, Madam Chair, and to the committee. My name is Ellie Williams. I work with Karima at the Georgia Coalition Against Domestic Violence, and I direct our Justice for Incarcerated Survivors program. So I'm a criminal defense attorney and provide post-conviction representation to survivors who are criminalized for something pertaining to their status as a survivor of abuse. So I don't have too much to add to what Karima said, but just want to reiterate our gratitude to Representative Reeves for understanding the necessity of constructing statutes and an infrastructure in the criminal legal system that has built-in protections for survivors who end up facing criminal charges for what's really a direct result of their victimization. We unfortunately see, as Karima noted, misidentification of victims as perpetrators. And so we wanted to, take the opportunity to ensure that this bill is constructed in a way that is protective of survivors. And we appreciate Representative Reeves and all of you all for understanding the necessity of not only how we respond to the law and litigate cases surrounding these statutes, but that the statutes themselves are built in such a way that protect survivors. So thank you for your consideration of this bill, and to Representative Reeves.
Thank you. Actually, if you can come back real quick, I think we have a question. Representative Miller?
Thank you. Thank you, Madam Chair. Thank you for coming down. I just wanted to clarify, and this might answer it for me. I was wondering why we changed primary aggressor to predominant aggressor. And I don't know if that's a better question for Representative Reeves. I know that we're sort of used to the lexicon of primary aggressor, and I'm assuming we're trying to get at something specific. So can you talk a little bit about that?
Sure. So primary tends, the word primary, and we in other statutes, Karima and other advocates before me worked really hard in other statutes to change the language from primary to predominant. So here, one reason for the proposed change is to remain consistent with other statutes in Georgia's code. But the reason behind the initial change in those statutes was that primary tends to implicate first in time. And sometimes we'll see situations where the evidence that the police have when determining who to arrest in a particular situation indicates that the survivor might have hit first. But according to, I don't want to get the name of the organization wrong, the Association for Police Chiefs, is that right? A national group. Predominant is a better word to use because it doesn't indicate necessarily who swung first, but who presents the greater threat when accounting for the overall dynamic of the relationship and the potential history of violence. So again, the proposed change does a more accurate job of indicating who presents threat, does a better job of protecting survivors from potentially being arrested, but also in this particular case remains more consistent with Georgia law on the whole.
Thank you.
Yeah.
Thank you.
Thank you.
Thomas Weaver?
Madam Chair, members of the committee, to be very brief, Representative Reeves' proposal is laudable. Just quick concern, when we begin to splice the intent versus unintentional, I begin to worry, and it's not just for this specific code section, it's anywhere in our criminal code. When we begin to splice what's intentional and what's unintentional, and then for the General Assembly to say, well, it doesn't matter either way, I think we're starting to eat at mens rea. That culpable mental state, that intent, we're starting to kind of like where Pac-Man gets to the dots. We're starting to eat into that theory there, and it just makes it so much easier and more convenient for prosecutors to be able to bring a case, and for a defendant, especially for the average person, if you've ever tried to read the Georgia Controlled Substances Act, you have to be a chemist to understand half of it, and you have to be very well legally versed to understand the other half. For someone to unintentionally violate that law, even in regards to probably even medication that they have at their own home, that maybe a pill was not in its original container or something technical or simple that could invite, well, I didn't mean to, it doesn't matter under this. A child was present, they saw it, it's over. So to begin to eat at the mens rea, that culpable mental state, and to be able to splice those and say, well, either intentional or unintentional, I just think that starts to get to a very, it's my personal private opinion, the legislature speaks for itself, but I think it starts to become perilous. And the laudable public policy aims of this particular code section and is admirable. I just would ask that this subcommittee give deference to when we begin to splice things and say, well, it doesn't even matter if you didn't mean to, be it on this or any statute. I just think that's a significant public policy consideration that maybe the legislature might want to consider further.
Thank you. All right. I think that's everybody that's signed up. I will. Representative Reeves, do you want to
Sure, just responding.
Very briefly.
You bet. Responding to some of those notions, you know, we all heard about that tragedy, I believe it was in New York, of a baby ingesting fentanyl. You had people dealing fentanyl around a baby, and the baby got it, and the baby was hurt. This bill says, let's go a step further and say, don't be dealing drugs around kids. Keep the kids safe from, you know, drug dealing and having those drugs around them. Secondly, you know, don't let those children witness permanently traumatic instances where if they got hit, it would be a serious crime. If they fortunately don't get physical violence, they're still going to have that trauma. Keep those kids safe from that. And then Section 2, enact the laws that some of our neighboring states have of cracking down on child molesters traveling to Georgia to molest kids. So just, you know, take these 3 steps to protect children from harm in ways that could damage them for life that are not contemplated under current Georgia law. Thank you.
Okay, Representative Byrd has a question.
Thank you, Madam Chair. Thank you, Representative Reeves. So I've been involved in foster care for the last 15 years. And the majority of children have been taken away from their parents for exactly the thing that we're stating right here. So with 11,000 plus children that are in foster care already, their parent or parents or grandparents or whoever were their guardian are already in prison or serving time. So is there not any law already that is on the books that?
No. The Sergeant Lawson and Chairwoman Taylor and everybody, you know, who's looked at this bill, these are 3 areas where Georgia law has a gap a mile wide, and some of our neighbors have better laws on. But if you listen to the domestic violence folks, the work they're doing, I think those kids and those victims of domestic violence who are their other parent would be much better off having those predominant aggressors and those drug dealers in jail. Life would be better off, and maybe they wouldn't need foster care if you get the criminals out of those kids' lives in a way that's harming them permanently. This is protecting kids from drug dealers, from people who are engaged in physical violence in the presence of the kids, as well as who are traveling to Georgia to molest kids. So I think those kids would be better off, and in the long run will have less of a need for foster care if you get these criminals out of those kids' lives.
Chairman Smith?
Yes, thank you, Madam Chair, and thank you, Vice Chairman Reeves. Is there a gap in the case law that you found that creates the reason for bringing this legislation? Because I'm sitting here thinking about the criminal negligence part of this. And so is there a gap in the case law that is behind the reason in you bringing this legislation? And if there's a gap in it, do you have a case cite for us that would be very informative on the matter?
Sergeant Lawson's letter does cite a number of cases, but that issue about the drugs, if the drug dealer has the drugs out on the table in the house with the kids, if one of the kids touches the drugs and gets into the drugs, that would be a crime. However, one step back from that falls short of Georgia law presently.
So it's interesting in this Jones versus State case. I understand your intent, but this is talking about exposing a child to marijuana smoke.
And we carved out marijuana. We're talking about, cocaine and other.
So if somebody vapes or smokes a cigarette in front of a child, are we sure that this wouldn't be used against them? Because let's just say, fast forward or, transport in time, both of my grandparents smoking cigarettes in the house with me. Yeah. If we get a prosecutor that doesn't like them for some reason, and, they could.
Well, cigarettes and vape, I don't believe, are controlled substances.
Okay, you don't believe, or are we sure?
If you start putting substances in the vapes, I think that's when you cross the line. But this is unlawful manufacture, distribution, delivery, possession, sale, or use of any controlled substance excluding marijuana. So unlawful controlled substance, and that category of activity. Okay. If that's too broad and use, this is aimed at keeping kids away from drug dealers in their house.
Thank you.
Thanks.
All right, any other questions? All right, and then I'll take any motions. All right, we have no motion. So we'll keep it at that. Thank you so much,
All right.
Representative.
Thank you.
All right, last bill, Representative Miller. Yes. Yeah, of course. I'm sorry, what was your number? Okay.
Okay. Thank you, Madam Chair, and we are working from, this is HB 1164, and we're working from LC number 481167S, which is a substitute bill.
Sorry, we don't have that in our folder.
You do not?
No.
Well, I thought we did. As it turns out, I have copies for everyone.
Oh, wow, look at, that is a great lawyer there. Extra points for being extra prepared. Thank you, Representative.
Motion to pass.
Let's do it. Clint's ready to go. Clint's just ready to go home.
No, we gotta
Okay, I will be fast in the interest of time. I have tried to talk to most folks on the committee a little bit about this bill, but essentially everyone should have a copy now. It is a modification to our very popular criminal trespass statute this year. Essentially, what this bill would do is provide for the offense of criminal trespass involving a wild animal. This bill is targeted at institutions like zoos, aquariums, animal safaris, basically any place where a wild animal is housed or kept for entertainment, education, and for other purposes as specified in the statute. But essentially, it's for zoos, animal sanctuaries, aquariums, and animal safaris. And what we have, what we've noticed in the year, and full disclosure, the Atlanta Zoo is in my district, and a wonderful institution in the Grant Park neighborhood and the city of Atlanta that has provided entertainment and education to families and students for a very long time. It is a beloved part of the Grant Park community. And we are trying to protect both the patrons of the Atlanta Zoo, to include children and families, and the animals themselves. And essentially, a person would violate criminal trespass involving a wild animal if, without permission, the person enters into an animal enclosure and harasses the animal, or the actual wild animal suffers injury or death. That would be the first, what we would call the offense of criminal trespass in the first degree. Criminal trespass in the second degree essentially would also involve a breach of a cage, enclosure, or other place where a wild animal is secured, but would not require the actual injury to the animal. And I think what differentiates, at least in my mind, animal enclosures where wild animals are kept is that the act itself of getting into an enclosure is dangerous. It is dangerous for the person who does it. It is dangerous for the animal. We have seen some very high-profile instances across the country and across the world where folks have done things that I know Representative Byrd would just find to be plain old stupid, as she told me, but have entered into enclosures where there are obviously very dangerous wild animals, gorillas, lions, tigers.
And bears, oh my.
And for all kinds of reasons, none of them good, none of them appropriate, to take a selfie with the animal, to try to pet the animal, to get a closer look at the animal. And what this bill would provide is a very clear opportunity for zoos and institutions like zoos to educate the public on why it is not okay at all ever to enter an enclosure, and to provide the appropriate sanction to back that up. I mean, I think it's already pretty clear in the zoo that you're not supposed to get in these enclosures, but surprisingly, people do. We've had a number of instances at the Atlanta Zoo where people have breached the gorilla exhibit, lion enclosures, multiple times. The lions are very popular, apparently, but people get into the enclosures for all kinds of reasons, to take better photos, et cetera, to get better looks. And we just want to make sure that this does not turn into a disaster at our zoo that would traumatize everyone, including other patrons, any person that is hurt. And of course, often these instances involve the ultimate death of the animal, who people have spent a lot of time, a lot of money, a lot of care to provide for, to care for, to nurture, and to house. That is in essence the bill. I won't talk too long. It is a marriage of the criminal trespass statute and that statute's close cousin, the criminal damage to property statute. It tracks the misdemeanor provisions under criminal trespass and penalties under criminal trespass, and the felony sanction under felony criminal damage to property. So there's really no increase in the amount of time a person could get. It just clarifies that a criminal trespass would involve an enclosure as defined in the act involving a wild animal, and if the animal is hurt or harassed, which creates a high risk of the person or the animal getting hurt, that would be a felony, and if it is not, then it would be a misdemeanor. It also would require, lastly, that any damage to the animal, if the animal has to be killed or put down, or the animal is injured in any way by a violation of this statute, that the person responsible would be required to pay restitution to the institution that has cared for the animal. So that's the bill in a nutshell. I'm happy to talk more with anyone who wants to talk more, who haven't already talked their head off about this bill.
Chairman Smith, we have one question.
This is not the Harambe bill, is it?
It's not called that bill, but Harambe does have I feel very bad for what happened to Harambe.
I was just wondering. I was curious.
I mean, we were trying to come up with a title.
I mean, a little bit of cultural awareness there. So thank you.
Thank you, Mr. Chairman.
Representative Roberts.
I'm sorry, I can't help it. Who testifies to whether it's been harassed?
Well, that's a good question, and in fact, I will let y'all know that Representative. Yeah, we got someone we've got some folks from PAC, Animal Protection, Animal Cruelty Unit, that's going to speak a little bit about that. But essentially, this would be probably common sense a lot, but certainly zookeepers and those folks who care for the animals, who have knowledge about the animals, would be in a position to talk about what would be harassment of the animal. We got the definition. We spent some time figuring out how to define harassing an animal. We looked to the U.S. Fish and Wildlife definition of harass, and somewhat cribbed that with the help from the PAC folks, who kind of helped us come up with that harass definition. But yeah, I think it would be common sense for the most part, but also certainly expert testimony if necessary.
All right, Chairman Leverett.
Thank you, Madam Chairman. So you've covered this, but so if you simply harass, and we're going to hear about harassment, the wild animal, if you just simply enter the enclosure, that's a misdemeanor.
Correct.
And the statute provides it can be punished by imprisonment for not more than 12 months.
Correct.
And I know you've got extensive expertise in the criminal code. Would a judge also be authorized, since it's a misdemeanor, to also impose a fine up to $1,000?
I don't believe we would have to include that in the statute. I do think the judge
It's implied
could.
by law because it's a misdemeanor.
I do believe that a
Okay.
prosecutor could ask for that and a judge could impose that.
And same with the felony, if you harass the animal and so simply harassing would not be enough to get into the first degree. You've got you've got to commit the act of harassing and the animal has to suffer some kind of injury or death as a result.
That's correct.
Is that right? Okay. And then that's a felony from 1 to 10 years.
Correct.
And presumably, too, the court has inherent authority to impose a fine as well as that, any kind of incarceration.
That is correct, and of course, the court always has the ability to fix restitution for any,
And you've provided that also expressly in the statute.
yes.
Okay. All right, thank you.
Thank you, Mr. Chairman. Make a motion to pass. Somebody's gonna speak
I,
to it.
I will take I previously heard the motion in a second, so I will take that up at this time. So we will do a vote on House Bill 1164, LC 481167S. All those in favor of passing that bill, say aye. Aye. Those opposed, same sign. All right, it passes. Thank you.
Thank you, Madam Chair.
And we are adjourned. Thank y'all.